And we are live on TCTV Channel 8 and YouTube.
Hello.
Hello, Ron.
Hi, Ron.
Welcome to the meeting.
Thank you.
All right, it's 6:30. The Templeton Board of Appeals will open a public hearing to consider a petition from the Brooks Village Community Coalition to consider an appeal of the building commissioner's determination. Is there someone here representing the Brooks Village Community Coalition?
Yes, sir, right here. David Pease Orchard will be presenting their brief.
Okay, David, what can you tell us?
Okay, well,
Concerns.
on behalf of the Brooks Village community, I want to thank the ZBA for taking our case regarding our appeal to the building inspector's letter of determination. We're here tonight to kind of get the wizard out from behind the curtain. We want to get our questions answered and the facility reviewed by the planning board. It is our contention that there was an overreach in this determination with respect to circumventing the process of review by the planning board, and a public hearing for community comment, questions, and input regarding the proposed, now presently under construction, compound. It is the community's contention that due process has been hijacked and the opportunity to be reviewed with respect to zoning applicability and the usage was bypassed by the officer's determination. The community was denied to be heard, and the planning board was also denied an opportunity to weigh in with respect to content and zoning bylaw consideration. We are appealing the opportunity to go to the planning board for review and public hearing for the community's voices to be heard for comment and discourse. Now, yes, the question comes out, what gives credence for review? Well, there's many things. Answering the questions of the community regarding the compound being constructed, but there's one particular example. And while reviewing the building permits, we found discrepancies with respect to what was on plan and as to what was being constructed. For example, the building facade doesn't follow the plan. Windows are where doors are, doors where windows are, and vice versa. And come to find out, the building is actually in the wrong location. Yeah, in the wrong location. According to the title block on the drawings, this building should be located at 1230 Plum Tree Road in Springfield, Massachusetts. So it's no wonder the building being constructed doesn't match the plans. So if these are the plans which were submitted for another project, what else is wrong with the permitting? Thus, the need for a planning board review. The Brooks Village Community Coalition is appealing the zoning officer's letter of determination regarding the decision to waive the need for a planning board review and a public hearing for the residents to voice their concerns regarding the construction of the proposed facility at 15 Carruth Road, Brooks Village. It's been stated that definition of this project does not require a planning board review or a public hearing for community discourse. Now, it's a two-sided coin. The permit was pulled for a 5-bedroom residence, quite benign, not requiring a planning board review, but not prohibiting one either. And that's an important fact, not prohibiting one either. However, when you start peeling the layers off this onion, you've got a completely different animal. You have something much greater than a typical single-family residence, and it requires scrutiny. If you've got a multi-$1,000 revenue incentive business machine here, equipped with overhead industrial parking lot lighting, alarm doors, 12 to even 24 car parking lot, potential 10 resident capacity, and a staff that could get up to as high as 30 people overseeing shifts and much more. Now, I think most of you folks are familiar with this map, the zoning map. And inside the yellow circle is the Brooks Village community, steeped with historical significance and is included in the historical districting of the town of Templeton. It was the crossroads of the Worcester to Keene Turnpike. Coveted with structures like the Spears House, which still stands today. Back in the day, the old Bulker Boot Factory and the Stagecoach Tavern Exchange Post was located in the crossroads in Brooks Village. The bucolic ambiance of Brooks Village is based in an agricultural residential setting, populated with hardworking, tax-paying citizens who chose to live in this zone setting. If you desire to wake up and walk across the street to a Starbucks, a Cumbies, or a Dunkin' Donuts, there is a zoned area that you can reside in that provides that particular entity. Brooks Village is zoned residential agricultural 2-acre. Now, very little information has come forth regarding the complex that is under construction. It is the community's understanding, and this understanding comes from a Conservation Commission meeting that took place back in July of 2020, that a 5-room group home capable of housing 10 non-related residents, supported by a potential staff of 30 employees, was being constructed. In our bylaws, which I know you folks are well aware, there are areas that have been designated home occupation major and home occupation minor. So what is this project, facility, or institution being classified in our zoning law? If this institution does not fit in any of our zoning laws, special variance would be needed or be granted. Now, in the letter of determination, the building inspector refers to the general law, part 1, title 7, chapter 48, section 3, as well as the CMR, the Code of Massachusetts regulations, interpreting that the Fair Housing Act and non-discrimination of disabled persons cannot be denied housing, superseding our bylaws. Now, this is somewhat convoluted. The fact that the DDS, the Department of Development Services, has a Big Tent, which covers many demographics like wayward delinquent youth housing, substance abuse facilities, felon entry halfway houses, and felon release housing, which are extensions of the criminal justice system. And the aforementioned dynamics are not subject to the general law referenced by the building inspector and are not permissible by our zoning bylaws. The Brooks Village community has a right to know what is coming into their community. We believe the building inspector's decision to bypass review and public comment denied due process. The community believes the inspector's letter of determination is in breach of the Town of Templeton zoning bylaws under section 300, article 3, and that a review by the town's planning board is in order, as well as a public hearing, so the community residents could be afforded their right to comment on this construction project. Additionally, the zoning concern is use of the facility. As to date, the abutters, the Brooks Village community, have not been informed as to what use is being applied to this congregate home that is under construction. And because the use of this facility has not been clearly defined to the residents, a public hearing on this subject needs to be addressed for public review and comment. The general law, part 1, title 7, chapter 48, section 3, as well as CMR, is not applicable to denying our appeal to conduct a forum for the community to be heard and a review by the planning board. Again, our appeal is based on review and public comment for the use. Again, it's a two-sided coin. The argument is it's both a residence and it's also a business. It is a residence, but it also falls into the realm of a business that will have more than 3 employees, possibly 10 one-on-ones, 3 shifts for a total of 30 employees, in addition to the zoning conflict, environmental concerns that have been raised throughout the construction of this project. And these issues need to be reviewed. Bear with me here. If you know, there's a tone of redundancy and it's purposeful. Again, our contention is that there is a dual application with regards to this facility, a business renting out residential lodging, and the utilization has not been defined as to the occupants. The facility differs in character to a single family residence There will be, as we said before, overhead industrial park lighting, which will be broadcasted to abutters properties, home environments, and line of sight. 24-car parking lot, security lighting and alarms, traffic loads, utility demands on the water supply delivery systems, and taxing the town services, to name a few issues. These issues need to be reviewed, and a discourse needs to take place. This facility should require a variance for approval to the zoning bylaws if the use is in conflict with our zoning bylaws. The residents of Brooks Village have a right to know what is coming into their community and a right to be heard. So the Brooks Village community is petitioning that a cease and desist order be put in place on this construction until these reviews, grievances, and public comment have been secured. So I think the question comes down now, when can we, the community of Brooks Village, expect a decision to be rendered on our appeal on the building inspector's letter of determination? And I want to thank you for your time and consideration with this on behalf of the Brooks Village community. Uh-oh. Did they hear anything? You guys there?
Yeah.
Oh, we can hear you.
Oh, okay.
The board's got a narrow scope on this. It's just hearing the zoning issue. And you brought up a lot of issues, a lot of different things here. Have you got some specific questions for Richard?
Oh, yeah, I think, well, specific to Richard? No, the only question that we have is, when can we expect a decision rendered on our appeal to get a public hearing and to get this to the planning board for review?
Yeah, that's not our jurisdiction. We can just have a hearing on the building inspector's decision. We can't force anybody else, other boards, to look at it or anything like that.
Okay, but that's what I'm appealing. I'm appealing Richard's interpretation, and where it falls short of allowing us the reviews that we're appealing for. We're appealing for a review, and we're appealing for the planning board to review this, because obviously it looks as though there's no reason why we shouldn't have those, based on the testimony that we provided.
Okay. Richard, do you have any response to these concerns?
Yes, I do. And I can speak for my letter and how I made my determination. And as Mr. Pease brought up, I did cite Mass General Law, Chapter 48, Section 3. And what that section of law is saying is you can't discriminate against people with disabilities. So this proposed group home is licensed through the state, to the best of my knowledge, through Department, DDS, Department of Developmental Services. And what Chapter 48, Section 3 is telling us is that it's a protected class. So there's something in Massachusetts called the Dover Amendment, and the Dover Amendment goes on to say that you can't zone out for schools, which is educational. You can't zone out for religious, and group homes that are licensed through the state are now classified and protected under the Dover Amendment as well. There was a recent Supreme Court justice case. It was the McLean Hospital versus the town of Lincoln. And it was this exact subject matter. Was a small group home for adolescent behavioral kids that were having problems. And rightfully so, the neighbors had concerns. They didn't know what was going on or who was going to be in there and stuff like that. But the Supreme Judicial Court ruled that a group home is a protected class. It is protected under the Dover Amendment, and that's how I made my determination.
And you've had other permits like this issued in town in the past?
I haven't for any group homes. There are numerous ones. I think there's a handful of them around town that exist. And again, again, the Dover Amendment is telling us you can't ask for a special permit for educational or religious use groups or for group homes now. That falls in that same category. They're treated and the group homes are treated as a single family residence. I know our bylaws, Templeton bylaws do say that you can only have up to X amount of people unrelated, but this trumps that. The local bylaw can't trump state law.
So there's no vehicle for a special permit or a site plan review of any kind.
It'd be no different than any other new house that was built on Carruth Road or up on that area. It's you can't ask who's moving in. You can't. So when those new homes are being built up on Carruth, you can't say what nationality is going to be the next buyer, what religion are they, what color are they. You can't. You can't. It's under the Fair Housing Act and the Federal Fair Housing Act. It's treated as a single family home as well.
You have any questions to that, Mr. Pease?
Yeah, I'd like to see what is it? You call it the Dover Amendment?
Yeah, so the Dover Amendment dates back to the 1950s, I believe. And the Dover Amendment is part of mass law, and what that does is it protects religious groups and it protects schools. You can set them in any zoning district without requiring a special permit for those use groups. And fast forward in life, now that we have group homes, because the state closed down all the other institutions, group homes have been linked into that because they are an educational use, because they're trying to reprogram people. They're trying to get them acclimated. They want them to be in the same environment as everybody else. They want them to live in communities. So that's how they fit into that equation.
So what is this? So what is this institution being built then? I mean,
It's classified as a single family residence. There could be 5 bedrooms, a 5-bedroom unit.
wow.
And it's classified as a single family dwelling under the state law.
With a potential of 10 clients.
It's whatever they are licensed through the state. The state licenses them. And you're assuming that every bedroom will have 2 occupants, and I don't know if that's the case or not.
That's what the engineer indicated.
No.
I'm sorry.
That is not the
Typically,
case.
typically
I can
the ones I've seen, it's one client per bedroom.
Well, I'm just going to go back on what the CIL's engineer indicated back at the Conservation Commission, that the capacity would be 2 per room, 5 bedrooms.
I think he meant that the septic system could handle that much load, but I'm telling you that for licensing purposes, it's 1 person per bedroom. So there will not be more than 5 individuals living in that house.
And what are we looking at as far as occupants?
Can you clarify that question?
Well, the demographics, I mean, are we talking about?
As Mr. Hanks has explained to you, that is information that you can't ask, and it's information that I cannot share with you.
Hello, my name is Peter Benvey. I'm a project manager for other group homes. I'm also with CIL Realty. The lease will be restricted to 5 people per the terms of the lease. And the house will be leased to the Department of Developmental Disabilities. And the residents will be clients with developmental disabilities. And further, the house will be deed restricted for people with developmental disabilities. So that won't change. It won't become a halfway house or whatever other type of house Mr. Pease was describing. It remains as a group home for people with disabilities, essentially people a little less fortunate, or sometimes a lot less fortunate than most of us.
So this is not going to be an extension of the criminal justice system?
No.
Because I don't think that has anything to do with, from what I can tell, from what our research indicated, that it does not have, it does not fall under that anti-discrimination venue that that Richard was talking about in the Dover Amendment or whatever, because
Well,
if you have an
in
extension, I guess, if you have
in
an extension of
addition-
the criminal justice system.
in addition to being project manager for over 100 group homes with CIL, I'm also a former chairman of the planning board for my town. And I'm not an attorney in terms of zoning issues, but I have more than a passing understanding of them as it relates to the state of Massachusetts. And as I said, it will remain a house for people with developmental disabilities. And by Mass General Law, that house is described legally as a single family residence.
So that's binding.
Yes, and in
As far as
terms
documents.
in terms of some of our funding requires a deed restriction that makes it, that guarantees that it can only be a house for people with developmental disabilities.
And does the town of Templeton have a copy of this document, or this, what you're talking about here?
The deed restriction,
Yeah,
I don't know, but we certainly can provide it.
yeah, okay, that's good. So getting back to our appealing of the letter of determination, will the community be afforded, or will there be a opportunity for the planning board to actually review this as well?
Under the terms of
I
Mass
see.
General Law, it's not part of the town's. The planning board doesn't have the opportunity to review a site plan.
If we don't require planning board of review for a single family house, we can't require for this house because it's treated the same as any other single family house. So unless the town had a provision that the planning board had to review every single family house proposed, then we can't impose something more stringent on this house just because of their class.
So it's sort of a, okay. What was the other thing I was talking about? So I'm going to move off that a little bit, but I want to come back to the public hearing for the community to voice their concerns as well as their input, relating to other issues that are associated with this. When will that decision be rendered that we could have an open meeting where people can actually voice? And this time, I suppose it's Zoom, but when can we expect a decision on that?
Who's that question submitted for? Who are you asking that question
Well,
to?
I guess I'm going back to the letter of determination, the fact that we've been denied an opportunity for the community to weigh in on this and to have their voices heard.
I believe he's already said that it is against the law. We cannot put any restrictions on this home that you cannot put on a single family home. And you can build a
Well, no,
single
I'm just-
family home without a hearing.
Yeah, I'm just saying, the folks out here have questions and they want to be able to direct them. You're saying that in other words, you're saying that's being denied, that's not going to happen.
Richard, can you elaborate on that?
Again, the only thing I can add to that is that, and I'm just gonna have to reverberate what I've been saying, is that unless you require some kind of review special to every single new home being built, this home is no different. It's a 5-bedroom house, 5 occupants. No clarification as to why they're there. It's no different than any other neighbor moving in next to you. If you see a moving truck next to you, you're gonna go ask, what religion are you? Where do you work? Or any of those questions. You can't do that.
Mr. Chairman,
Yes, Laurie.
could we please circle back? We have a question on YouTube regarding the plans for the house and how they are refer to Springfield and dated in 2019?
Okay, who could answer that? Richard,
I'm
have
not-
you seen?
this
What's the
is-
question? Because the title on the plan references Springfield versus Templeton. It's the building plan meets building code. It doesn't matter if it's where it says in Massachusetts, it falls in the Mass State Building Code. If they didn't change the title block because they built the same thing in Springfield, but as long as it met the state building code, I don't care really what the title says as far as, you know, it could say Acme Inc. on it for it, as long as it meets the state building code.
I believe they're questioning the placement of the building also.
Placement of the building, as long as they meet the setback requirements. So sometimes, you know, they'll propose a location and sometimes they get into it and it might not fit exactly what they thought. They feel that they need to adjust and move it something as long as they meet the setbacks. So they have a building envelope. So they got to be certain feet off the roads, off the rear property line, sidelines. So as long as they're building within that building envelope, and obviously they're confined by the septic location, stuff like that. So again, numerous new houses, they propose a certain location, and when we get the as-built at the end showing where it truly ended up, they very rarely jive. You know, that once you get into it and you might hit ledge, you might hit some other impediment that they end up moving it from where it's proposed location. So we always start with a proposed location. We look at it, make sure it meets the setback requirements and everything else. But again, once they actually put that foundation in the ground, then we ask for an as-built so we know where it truly is. And what we're looking for is make sure it meets the setbacks of the required zoning district.
To further on that, there's a comment that the placement of it's not so much the placement of the building, it's the design of the building does not match that current build. That's a comment on YouTube.
I don't follow that question. What do you mean that the design doesn't match what?
The plans.
I haven't seen what's being built. I approved a certain plan. So I don't know how to comment beyond that.
To that
If I
point,
receive,
go ahead, I'm sorry. Well,
no,
to that
go ahead.
Well, to that point, Richard, does that mean you should go out and take a look at see if those plans match up? And is that
Well, eventually I will get a call to go look at the framing inspection when they call because they're ready. If you tell me that the actual construction is not meeting the plan, I guess I can go take a look at it and see what's different about it.
The person
got it.
questioning that, do they have something specific? Do they have anything specific that's wrong, or have they seen the plan?
well, the plan was released. We have the plans.
You have the plans.
Yeah, well, I found out that the building was actually in Springfield, and maybe Springfield's building or our building is in Springfield, you know.
It's a quick note that the plan submitted to the towns do state 15 Carruth Templeton. So it is possible that you're working off a version that's not up to date.
So I guess one of the things is we'd have to dig out our plan here and see what ours is called. And maybe the plan that you got was from Springfield, and that's why they're not looking the same. I don't know, where did you get your plan from, Mr.
You
P?
guys.
Okay, well, that's a good starting point.
I got a question kind of off the side here a little bit, but and because the focus of this appeal was basically to get a public hearing for the folks, for the community to have their questions reviewed, and as well as getting it to the planning board. But what's the estimated property taxes applied to this business anyway?
That I don't know. If you go by the cost of construction times your tax rate, you could try, so. And I'm not the assessor. I don't know what they're gonna put for value on it.
Oh, so this facility will be paying property taxes to the town of Templeton.
I can't answer that question.
Well, how about have somebody from Sill? I mean, they own the property. They must know what the estimated taxes are going to be paid to the town, correct?
That's not a question that I could answer at this time. The house isn't complete yet. And that's a determination that we based on that the town would have to make.
Oh, so obviously you will be paying property taxes.
Again, that's a question that you would have to ask the assessor's office.
I got a question.
Yeah, go ahead.
Well, answer this question. Overall, in most of these homes, do they have to pay taxes to the towns or cities that they're in? Can they answer that question?
Diana, do you know an answer on that, on other homes?
So it really depends on the town. Since CIL is a nonprofit, we do apply to the towns for tax abatement, but at the end of the day, it's within each town's purview on whether or not they decide to grant that. So it's not a question that I can answer for Templeton. And
Could
as
you-
of right now, since the house is still under construction, we do pay property taxes. It's only after the house is occupied that we submit that application.
And we're getting off track a little bit here. It's really whether it pays taxes or not. It's got nothing to do with the issuance of a building
No,
permit.
I know, but I just brought that up because there's, you know, if we're gonna get down the road where we're gonna have some public or discourse, I don't know if that's gonna happen now. It sounds bleak from what I'm hearing this evening, that the community is gonna have an opportunity to put forth some questions on this.
Yeah, you know, the board's got to make a determination on where the building inspector, you're claiming he made a mistake. And, you know, it's a legal issue. You know, you have to give us proof that he made a legal mistake in issuing a building permit for this site. And unless the board hears something that we don't have a choice, you know.
No, we were just pointing out discrepancies in the plans, and obviously we're not experts. I know I'm not, but when you see something labeled a dog and it's actually a cat, we got a problem. You know what I mean? That's kind of what we're kind of alluding to. So if it's you folks that go double check and make sure everything's hunky dory with the plans and it's all set up, this is, you know, I don't know if this is a cut and paste job that didn't get pasted or he got cut or something like that. But
Well,
it brings
that's
into
your
question-
job as the appellant. That's your job. It's not this
Oh, it's our
board's job to go out. It's not this board's job to go out and find a reason to
No, okay.
overturn the building inspector's decision.
Yeah.
We're here to listen to you. Tell us why. You got to tell us why the building inspector is wrong. That's not this board's job. That's your job to prove to this board that the building inspector erred in his decision.
Did I bring enough proof today?
Well, we'll have to have a board.
Good effort.
Vote on that.
I don't know. I thought we had a rock solid case when I started this deal.
Well,
Get an admission of guilt from the building inspector, maybe.
I don't know. He's turning red. He's turning red, or I'm losing some lighting in there.
No, I turn red easy, but you, Mr. Keys, yes, this is not, if it's not what you're used to and everything else, then it does look odd. I agree with you 100% on that. And but I have to stick to what I know as to civil rights and discrimination law. And again, they're treated as single family homes, and we can't ask those questions that you would like answers to. So, and again, it's no different than anybody else moving into your neighborhood. You can't see the moving truck and say, hey, what religion are you? Or, hey, you look a little different. What's up with you? So you can't ask that stuff. They have to be part of society. They have to be blended in. They have to live in an environment just like you and I.
We would just want to know about the criminal element, if it was going to be a criminal element, but obviously Sil reported that their deed is structured for disabled individuals or whatever, and that's what it's been locked into, and they're going to provide that deed, that information to the town, and that way they're
Deed restriction will be on their deed, so that's on the land records. So these will be searched to prove that they.
Okay, kind of broken up. Maybe it's on my end. It got broken up.
Oh, I'm sorry. What I was saying is that they do a deed restriction on the property. It gets recorded on the property deed, and that can easily be researched on Mass Land. You type in the property address for Worcester County, and it'll bring up any that's legally been recorded on that property. So that's easy to look up to verify that they've recorded the deed restriction.
Okay, thank you.
You're welcome.
Mr. Chairman, we
Yes.
have a question with regard to sex offenders being classified as disabled. I don't know if anybody can answer that or not.
I'm not touching it.
I'm not.
I don't know, that's not my expertise.
I don't think we have a right for that one.
We also have a question with regard to the roof going on and the plans are mirrored. Will there be further review of the plans since there's questions about where everything is going?
The mirroring of a plan doesn't really matter. It's the same building, just reversed. Again, I'll be going through it for code compliance, make sure it's built to Mass State Building Code.
Thank you.
Welcome.
Okay, any board members have any other concerns or issues they want to bring up?
I don't.
Ron, how about, you got anything to offer?
No, I'm all set. I know there's like 5 or 6 of these homes that are in town already. We've never had any issues with them.
There are, Ron, and I actually have a printout here. I don't know if anybody can see it of that. I don't know if it's gonna show up, but those are the places that are in town, and there seems to be 8 or 9 of them, and there hasn't been any problems, so you can go from there.
I just have another question because of, will there be any concessions or considerations to the abutters for privacy amendments put in, such as fencing or plant materials or something like that, to kind of reestablish the ambiance that was once there as a farmstead?
Absolutely.
That would be under the planning board, wouldn't it? They'd have to discuss that with, if they want the fences in and for privacy.
Discrimination.
I can speak to our intent is to generally, we'd like to, make the neighbors happy. So if the neighbors want a little bit of landscaping or fencing, we generally try to oblige within the means of our budget. So currently there are plans to put in at least a little bit of fencing along some portions of the property. Where exactly will be determined after the house is built.
Well, let me ask you, follow up with that. Could the residents who are concerned about that particular issue, the residents that are concerned about that issue, could they get directly in contact with you?
In terms of where they would like the fencing?
Well, yeah, whatever concessions, whatever they're looking for as far as privacy activity or whatever, to set back the like I said, to reset the ambiance of the farmstead kind of appeal to it, as well as giving it, this like it was indicated earlier by the community, was the concern of the lighting issues. And of course, up here, you don't have that kind of industrial park lighting blasting in all over the place. Even if it's low scape, of course, you can't, you get to see the stars at night. These are the concerns that were coming up in conversation when we met collectively on what our concerns were, not only from, again, I go back to the elements that would be involved in residing there, but also some of the environmental issues in nightscaping and all this other aspect that's involved.
Diana, I have a question directed to you on YouTube. It asks, would you be able to send up your drawings of the building and site plan? From what we saw before, we had a site lighting pole right outside a neighbor's window.
So the location of the lighting can be adjusted. So once we're ready to put in the posts, I have talked to our contractor to be cognizant of the location of those posts in relation to the neighbor's windows.
Thank you.
That's Zach on the other end doing it. Well, let me just check my notes here one more time. And I'll bring up this one, I know the community has put together questions of their own that are out there, but there is a storm drainage runoff water that's actually exiting right onto Carruth Road from what I guess we'd call the front portion of the property there. And most of it goes down into a butter's yard. Is there any plan to address installing catch basins or stormwater drainage before it enters the Carruth Road and gets diverted in a proper direction away from the butter's property?
Right now, I think what we're building, what was designed is what will be installed.
Yeah, well, no, I'm just concerned. We're concerned about the runoff coming off the hardscape with a much more greater velocity than it had when it was just a dirt driveway and it was able to percolate to a certain degree from friction loss and whatnot coming in. And right now, just wondering if that's going to be, is that going to continue, or is there going to be any remediation to that?
All I can say is that I trust the engineers that we hired and the design that they have come up with. And so that is currently what we'll be following.
Thank you, Diana. To add to that, Dave, I think that would be under a driveway permit. A lot of those issues, I believe single-family homes are subject to a driveway permit unless this was an existing driveway. I don't know. Richard, can you add on to that?
I don't believe it's an existing driveway, and I'm pretty sure that part of the plan review was Highway did look at that and issued a driveway permit, but we'd have to look into that. But I'm pretty sure that there was the process that they did get a driveway permit.
Yeah, because this project wouldn't be exempt from that.
No,
Every single family home is subject to the driveway permit.
correct.
Yeah.
But just to reiterate, and I'll state it, there is an issue with that problem right now. And we've provided visual evidence of the flow, the activity of that kind of thing. So, I mean, I think I don't know. We think it needs to be addressed. That's
Okay, but like I said, this meeting, this hearing is for the zoning aspect.
I know.
So we're getting pretty much off scope. So We got no
Okay.
more testimony to the zoning issue.
No, no, Chairman, I think that's pretty much our testimony regarding appealing the building inspector's letter of determination.
Okay. And no other questions from the audience or the board members?
I have no other on YouTube.
Okay, thank you, Laurie. I think we have a discussion on wrapping up the public hearing. Do we have any discussion, make a motion to close the public hearing at this time?
I'll make a motion to close the public hearing at this time.
Any discussion?
Nope.
All right. We take a vote. All those in favor, closing the public hearing?
Aye.
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 Okay. 7:15, public hearing has been closed. We want to thank you people for addressing the issues here, and hopefully you got a few of your questions answered, Dave. And
Yes, again, on behalf of the community up here, we thank you for your time and your consideration and allowing us an opportunity to appeal those particular issues that we have. And we've got some more information. I know we've got a little more work to do, but we appreciate the ZBA for taking on our case.
okay. Very good.
Thank you.
Now, board members want to stay on and vote on this tonight? What do you think?
Um,
All right, if I may. Oop, I don't know if I'm on.
Okay,
Everybody's got time to do it tonight?
Yes.
yes.
Okay, great. What are you guys thinking? They give us enough evidence to overturn the building inspector's decision, or?
I don't think so.
No.
I don't believe so either.
Yeah, I think, the Dover amendments is,
It's the law, is the law.
yeah, yeah. The Dover amendment is pretty clear on that. It's I don't believe it's a gray area or anything. I feel for the neighbors up there, I think they do have some legitimate concerns, and it's not, it's not a mistake of the building inspector to issue that permit. It's just the way the law is, and whether it's fair, right, or that's not for this board to decide. Are we ready for a vote?
Yes.
Sure.
All right. Take a motion, we deny the request for a overturning of the building inspector's decision to issue a building permit at 15 Carruth Road. All those in favor of overturning the decision? Say aye.
Aye.
No, I don't think you know what you voted for.
Oh, no, I'm sorry. No, I'm
There you
sorry.
go.
I apologize.
All
No,
right, why don't, we need a motion anyways. Somebody want to make a motion?
okay. Okay.
I make a motion that we vote tonight to resolve the building inspector's decision.
That we'll uphold the building inspector's decision.
Yeah.
That's correct.
All right, we'll uphold the building inspector's decision.
Yeah.
So all those in favor?
Aye.
Aye.
So yes for me.
That's a yes. Yes,
Yes.
for Dan.
Yes.
Yes,
Yes.
for Joe. And I'll vote yes as well. So that's a unanimous decision. So I'm not sure if we're denying, overturning, or we're upholding the building inspector's decision.
Both.
Both. All right, Laurie, are you confused or are you all set?
I got it all, and I can rewatch it if I need to.
Okay. Okay, very good. Guess we can wrap this up.
Well, I make a motion that we close the meeting.
Do I get a second?
I'll second it.
All right, all those in favor of closing the Board of Appeals meeting?
Aye.
Aye.
Aye. All right. Good meeting, guys.